Hey guys, Ray from bailbondbids.com. You've made bond. Don't waste that time. I've kind of stated this in some of the little YouTube video shorts, and I've talked about a tool that if you get out early enough and you retain or hire an attorney, sometimes you can push that attorney, if acceptable or if appropriate, to try to ask to present evidence before the grand jury. Unfortunately, a lot of times, by the time you're appointed counsel, if you don't hire an attorney, this period or this opportunity, if it's appropriate, would have passed. And remember, a grand jury is used for felonies only in the state of Texas, and it's different than the trial jury. Trial jury is, in front of a judge and prosecutor, defense witnesses, and emotions and photos. That's the trial jury, what we most think about. But this is the grand jury. Basically, they're impaneled for a month or two at a time in every county. And they're just citizens, and the prosecutors go in there and they present evidence or they talk about a case, and they basically stamp off and sign off on the charges, which make the case live in the court, formal charges. Okay, so remember, once again, as stated below, the grand jury in Texas is not the trial jury. It's kind of like if you have good evidence or good reason, it's a free bite at the apple to try to get a case dismissed. And the way it works, and once again, this is something you need to just talk to your attorney about after you make bond. It's an opportunity. It's a free bite at the apple that can be beneficial depending on the circumstances. And generally speaking, I would never go in front of a grand jury or present my client's case or in front of a grand jury if the prosecutor allows, unless we have really good evidence out there. But once again, like I've said in some of the YouTube shorts, I've probably had 15 give or take cases dismissed over the last 10 or 15 years by just preparing early and quickly and asking the prosecutor to present evidence to the grand jury. Basically, as I just stated, a grand jury seal is needed for the charge become formal. You have to ask the prosecutor, as stated below, and once again, as just stated, only with strong evidence. Now, the key is the grand jury can review it, or they can hear testimony, and they can no-bill the case. So a lot of times, there's politically sensitive cases because, like I've said on some YouTube shorts, prosecutors, their offices are elected. And sometimes there's a case where it's an alleged sexual assault or something of that nature, and the prosecutors don't necessarily believe the alleged victim. And is what they'll do is allow evidence or testimony or documents to be presented kind of when they're on the fence about it, or if they don't actually believe it, but they don't just want to dismiss it because they're afraid that family, that alleged victim, will get on the news and cause political drama. Or sometimes if they're just not real secure in the evidence to charge, and they'll let you present evidence to the grand jury. It's not appropriate in all cases, but many times or sometimes it is. So that's something that you should talk to an attorney about if you hire somebody. And again, unfortunately, if you're appointed, that usually comes later in the game, so that opportunity is lost. So just keep that in mind. And once again, if you make bond, which is why we exist at Bail Bond Bids now, which is the marketplace where family and friends can get competitive bonds with competitive terms, use that time and don't waste it. All right, guys, hope this helps. Bye-bye.